Hello students and welcome to the next session of Companies Act 2013, that is company law. So far we have discussed during last session about the director's role, the board of directors, appointment, the types of various types of directors, okay, uh, the powers of the duties of the board of directors, the vacation of the office of the board of director, the disqualification qualification criterias. Today we are going to proceed further and we will talk about meetings of the board of directors and the various committees. So meetings of the board of directors and its powers, we can say that. So we will talk about meetings of BoD and its powers. So first we need to understand why the meetings of the BoDs are important. Okay, so shareholders in the general meetings and the directors acting collectively as the board of directors, what we have seen, okay, they conduct the affairs of the company. So directors, they frequently meet and discuss, okay, various matters relating to the management and administration of the affairs of the company. So that has to be done in the interest of the shareholders, the company and the public at large when the public money is involved. So more particularly the environment also, the modern practice is to confer upon directors the right to exercise all the powers of the company in which they are appointed as the directors. So except where the powers are given expressly to the shareholders of the company, all other powers, okay, basically can be given to the board of directors. So the board of directors oversees the overall management of the company to ensure that the interests of the shareholders are protected and the goal of the profit maximization of the company will be achieved. So that is the reason there are provisions given for the meetings of the board of directors, okay, from section number 173 onwards, as well as there are corresponding rules, secretarial standards prescribed by the Institute of Company Secretaries of India will have to be complied with, okay, when we are talking about the board of directors. So the first provision we are going to start with the meetings of the board, that is given under section 173. So meetings of board section is section 173. So this section talks about the overall provisions relating to the meetings of the board. So it requires directors upon whose shoulders the management of the company rests to meet and interact regularly. So that the aim is to ensure that the powers which vest in the director should be exercised collectively, and every director should have the knowledge of the decisions taken for the smooth conduct of the business operations. So this particular provision talks about the meetings, how it should be conducted. So we can say that meetings should be conducted. So like section number 173(1) talks about the frequency of the meeting. Okay, so the first BoD, so when the company gets incorporated, the first BoD of the company, and then we will talk about subsequent BoDs. Subsequent BoDs. Okay, so the first BoD of the company, every company shall hold its first BoD within 30 days from the date of incorporation. So first BoD, what we can say, within 30 days from incorporation. And what about the subsequent BoDs? Minimum 4 BoDs every year, but gap between two BoDs should not be more than 120 days. Should not be more than 120 days. That is the criteria. Okay. So first BoD has to be conducted within 30 days from the date of its incorporation, and the subsequent BoDs, minimum 4 BoDs every year should be conducted. So when we say every year, means every financial year should be conducted. Okay, but the gap between two BoDs should not be more than 120 days. So company will have to ensure that, okay, the gap between two BoDs should not be more than, okay, 120 days. So the second BoD, let's assume that if I conduct the BoD on 2nd of April 2020, okay, then I have to calculate from 2nd of April till 120 days. My next BoD should be conducted within that particular period. Okay, so why this is the case? Because every quarter one BoD has to be conducted. That is the main logic behind, okay, this particular provision. Now these there are some companies which are exempted. So exemption has been given to few companies. So exemption is given to the one-person companies, small companies, where they can conduct the board of directors meeting in half year. Means there can be 2 board meetings. Now, okay, after that we need to talk about participation by directors in the board meeting. After understanding this, we'll talk about participation by directors in board meeting. Now how directors can participate? Okay, the section, okay, I have not quoted the section. Yeah, this is section 173. We are just talking about 173 only. Okay, so the 173 subsection 2 allows the director of the company to attend the meeting in different ways. Okay, how he can attend the meeting? So we can say that as per section 173(2), the directors may attend BoD in following manner. So the first one is in person, that is through physical presence, then or through video conferencing, through other prescribed audio visual means. Okay, so directors are allowed to attend meetings in these particular manners. Either they can remain present physically during the board meeting, or through video conferencing, or other prescribed audio visual means, okay, as per the rules. So there are rules of meetings of companies, meetings of board and its powers, rules 2014. Company will have to ensure, okay, company will have to comply with that, then only they can, okay, attain. The board of directors can attain through these particular means. But there are few matters which cannot be taken or cannot be dealt in a meeting, okay, through electronic mode. So these matters, okay, as per the rules, there are few matters which cannot be taken during the meeting of the video conferencing means. Okay, which are those matters? We'll try to understand in the next slide. Matters which cannot be dealt with in a meeting through electronic mode. So which are those matters? Okay, so the central government has by notification, okay, specified certain matters which cannot be taken up with through the electronic mode. So either by video conferencing or audio visual means. So the matters like the approval of the annual financial statements, annual financial statements, the approval of annual financial statement, the approval of board's report, the approval of board's report, the approval of prospectus, the audit committee meeting, or consideration of financial statements, and the approval of merger, demerger, acquisition and takeover. Merger, demerger, acquisitions and takeover. So the company law expects that the board of directors, when they are meeting for all these matters, they should meet in person and pass the resolution. So these resolutions cannot be passed through electronic mode. So the meeting cannot be conducted via video conferencing or audio visual means for all these matters. So just to conduct the procedure, there are some procedural aspects given for conducting the meetings through electronic means. Like the procedural aspects relating to the electronic means, when the company is conducting, it should avoid failure of any video or audio visual connection, because the board meeting is a very crucial meeting for the company's point of view. The chairperson of the meeting and the company secretary shall take due and reasonable care that sufficient security and identification procedures are there. No other person is attending that meeting. The record of meeting can be done properly. It should be stored properly, okay, for a minimum period of 1 year. So participation attending the meeting through our all the participants are able to hear, okay, and see other participants clearly during the course of the meeting. The notice of the meeting should provide that, okay, the option should be given. It should be informed to the directors that they can attend through video conferencing board or other audio visuals, so that they can, okay, intimate to the company related to that matter. So basically a director who wants to attend the meeting through video conferencing should give his intention, should inform about its intention, okay, to attend the meeting through video conferencing. All these particular procedures should be properly taken care of. After after the meeting, at the commencement of the meeting, roll call should be taken about the name, the location from where the director is participating, whether he has received the agenda or relevant papers or not. He has to declare that no one, okay, other than the concerned director is attaining or having access to the proceedings of the meeting. So after the call, okay, all these recordings should be properly maintained. And the person who is the director who is attending the meeting through video conference will be counted in the quorum as well. The statutory register shall be deemed to have been signed by the directors participating through electronic means. So all these particular, okay, you can say compliances should be complied with. After the meeting, post meeting, the summary of the decision of each agenda should be given, and the chairperson should announce the summary of each agenda, okay, and the minutes should be properly preserved for this video conferencing meeting. And of course after signing, okay, like any other meetings, the minutes should be, okay, attached with the minutes book of the company. So these are all some of the aspects, okay, the board will have to take care of that, okay, even the company secretary and the board for that matter. So it is not necessary for all directors to attend board meeting, okay, to during a year. So company law says that a board of director will have to attend at least one meeting during a year, because it is it may be illogical to expect that every director will attend every meeting, okay, because they are the guardians of the company. But however, the continuous absence will be detrimental to the interest of the company, and that is the reason the board of directors, a director in the board is expected to attend at least one board meeting in a year. And if he does not attend the meeting, okay, during the year, then he will have to vacate the office. That may become the disqualification. So let's try to understand now notice of BoD. Notice of board meeting. As I told you earlier, okay, company will have to comply with the secretarial standards also while conducting board meetings, general meetings, that we have already done in the previous sessions. Section 173(3). Okay, so let's talk about notice of the board meeting. So period of notice, at least 7 days notice in writing should be given to the director. So that can be, okay, there are two types of notices, or you can say two types, okay, shorter notice, less than 7 days also can be done. So we can understand this in two different ways. So one is at least 7 days notice in writing, and second one is shorter notice. So shorter notice means less than 7 days, less than 7 days. Okay, this provision is also there. Okay, so if normally, okay, the 7 days notice should be given in writing to all the directors or at their register address, to all directors at register address or by electronic means. Okay, so we can say that at least 7 days notice is required. This is the notice criteria. And shorter notice if it is of the urgent matter that board will have to meet, then this is the provision made in the Companies Act. Okay, so this is basically to transact urgent business. To transact urgent business, this notice will be required. So at least one director, at least one independent director should be present. Okay, so this is the criteria. Okay, if the shorter notice BOD is to be convened, you have to, okay, have the urgent business and one independent director if the company is required to appoint the independent director. So on receipt of the notice, we have already discussed, if it is to be convened through video conferencing, the director who is intending to attend the meeting through video conferencing should inform the company that is going to attend from this particular place and the arrangement has to be made. If there is the notice, if notice is not given properly, then okay, there is a penalty levied. Okay, a penalty of rupees 25,000 in respect of every officer of the company, okay, will be there. Okay, so what is the penalty part? Penalty section 173(4). Okay, so fine of rupees 25k on every officer. Okay, in default. So whose duty was to give the notice and he has not given properly the notice, then there will be penalties. So we have completed section number 173 relating to the meetings of the board. Now we will talk about the quorum requirement during the meeting. So let's talk about that. Quorum for meetings of board. Quorum for meetings of board. Okay, so what is the quorum requirement? To quorum we have already studied in the general meetings is the minimum number of director who must attend the meetings proceedings in order to transact the business. Okay, so directors must not be disqualified to participate in the meeting. Unless the quorum is present, it shall not be deemed to have been properly, the meeting should not be deemed to have been properly convened. And that is the reason the quorum requirement is given, okay, under section 174. So I'll just write down the pointers. The quorum for board meeting shall be 1/3 total strength or 2 directors. Okay, 2 directors, whichever is higher. So one third or two directors, whichever is higher. So if my company is having three directors on my board, then my quorum will be two because my higher number is two. If my company is having nine directors, then one third becomes three. Then my whichever is higher is three. Then three will be my quorum. The quorum needs to be present throughout the meeting. Throughout the meeting. Then participation through electronic means to be counted for quorum. Okay, so if they are attending the meeting, okay, through electronic means, then also it should be counted as quorum. If any directors is interested in the matter as per section 184, then in that particular case, then the other directors may form the quorum. Okay, but the other directors will have to ensure that the quorum is present during the meeting. Meeting may be adjourned to next week for the want of quorum. For the want of quorum. Okay, on the same day, at the same time and the place, the next week, okay, meeting can be conducted. Okay, if the quorum is not present. So these are the requirements for the quorum. I hope you have understood. So please make a note of all these pointers from section 173 and 175. So we started with 173. 174, the quorum requirement. Now we will talk about passing of resolution by circulation. Passing of resolution by circulation. Section 175. Okay, so always it is not possible to meet, and not all matters are very urgent where the board has to meet and discuss upon the matter. So there can be some matters which are not very urgent but of the routine nature, okay, where the decision can be given by circulation. So where the requirement, or you can say where the personal presence may not be required for those matters, and board of directors can give their approval through various modes. So 175 along with the rules of the company's meeting of boards and powers, rules 2014 contains some provisions for the circulation resolution. So board is conducted to pass the resolution that we have already studied. So as I told you, there are certain matters which according to Companies Act can only be considered and decided during the board meeting, like passing the annual financial statement. You cannot just pass by the circulation. So there can be some routine matters, which can definitely be passed, which are not that important, and therefore, does not require its consideration at the board meeting. Because conducting the board meeting can be sometimes the expensive task, because the board of directors will have to come down and attend the meeting, the sitting fees have to be paid. So in that particular case, circulation, matters can be done. So there are some rules regarding that. A resolution shall be deemed to have been passed duly passed by the board or committee thereof by circulation in case so we can say a resolution has been, shall be, deemed to have been duly passed by board or committee by circulation in case the resolution has been circulated in draft. Together with necessary papers. Together with necessary papers. At register address, or by electronic mode. This is the requirement. Papers should be properly given, circulated in draft, with necessary papers should be given to the directors, so that directors can take the decision whether to accept it or reject it. If it has been approved by majority of the directors who are entitled to vote, who are entitled to vote. Okay, so by majority, okay, the circular resolution can be passed. But if at least one third of the total number of directors, okay, uh, decide that the circular resolution should not be passed and the matter should be taken up in the board, then chairman will have to put that particular resolution during the meeting of the board. If one third directors, the one third directors require to take circular resolution at board, then chairman will have to act accordingly. Okay, noting of past resolution, noting of past resolution in next meeting. So whatever the resolution has been passed, okay, it should be noted in the next meeting, it should be taken up in the next meeting and approved, and it should be made a part of the next meeting minutes, because the in between when the circular resolutions are passed, it should be taken up in the meeting, so that the board of directors will give the formal approval on that particular circular resolution. So if one third directors want that, okay, circular resolution should not be passed and it should be taken up during the board meeting, deliberation should happen, so the chairman will act accordingly and it should be noted, okay, in the next meeting of the board. So these are the rules regarding the circular resolution, which is one of the criteria, or you can say one of the facility given to the board of directors, so that they can pass the circular resolution and they can take the urgent matter during the meetings, during the during the gap of 2 board meetings. There is one more only small provision: defects in appointment of directors not to invalidate actions taken. This is just to protect the interest of the company and the decisions which have already been taken by the board of directors. So this provision says that it is a kind of protective provision, you can say, by which actions taken by the board shall not get invalidated. So actions taken by board will not get invalidated if subsequently it is noticed that there happened to be the defects in the appointment of the director and that particular director was present in the meeting. So validation of the action provides a kind of protection to the company as well as third party. So no act done by a person as a director shall be invalid if it was subsequently found that there was any defect in the appointment, disqualification, but it was found subsequently. So it is in the interest of the company, okay, to protect the that particular resolution. The small provision. So please make a note of this particular provision. 175. we are going to talk about the committees of the directors. So now we'll talk about the committees, various committees of the board. Various committees of board. So we can have various mechanism, okay, where the board of directors will have the subcommittee to deal with particular matters. So first is of course the audit committee. Then there can be vigil mechanism. It's a kind of mechanism, we will talk about that. Then there can be nomination and remuneration committee. Then stakeholders relationship committee. Okay, so these are the subcommittees, mandatory subcommittees of the board of directors, which the prescribed company should have. Okay, not all companies should have the these types of committees, but the prescribed companies, okay, should have all these committees. So for a better corporate governance, even if the company is not required to have the audit committee or all these committees, okay, private limited companies or for the companies which are not prescribed, they can take the decision to have all these subcommittees, okay, for the corporate governance purpose. So one by one we'll try to understand. So first we'll try to understand the audit committee. Audit committee, section 177. Okay, section 177 subsection 1, along with the rules of course. Okay, so audit committee, basically the few companies, okay, should have, following companies are required to have audit committees. We can say following are required to have audit committee. So first one is every listed company. All listed companies should have. Public companies, whether it is listed or not, public companies, if they are having share capital of more than 10 CR or more share capital, of course paid up share capital, I should mention paid up share capital, and then public companies again those who are having turnover of 100 CR or more, turnover, public companies, okay, which have in aggregate outstanding loan debenture deposits rupees 50 CR or more, outstanding loans, debentures, deposits, etc. Okay, so these companies are required to have the audit committee. Okay, so audit committee, we will talk about audit committee, the constitution of the audit committee as well. So let's talk about composition of audit committee. Composition of audit committee. Okay, so what is the composition of audit committee? For that matter, it shall have minimum 3 directors with independent director forming a majority. Since okay, it is mandatory for a public limited companies to have, the public limited company will have the independent directors, so it shall consist of, it shall consist of minimum 3 directors with IDs, that is independent directors, forming majority. Okay, forming majority. So minimum 3 directors and the independent directors should form the majority. And this is one of the requirement. And second requirement is majority members of audit committee including its chairperson shall be persons with ability to read and understand financial statements. So financial statements, they should be in a position to understand. Majority members, then only they can give justice to the audit committee work. Okay, so disclosures of the composition should be made in the board report. Then responsibilities of the audit committee are given under section 177(4). So they can recommend for the appointment and the remuneration and terms of appointment of auditors, review and monitors auditors' independence, performance, examine the financial statement as auditor reports thereon. They can give approval or any subsequent modification of transaction of the company to the related parties transaction. So there are various roles, okay, various duties prescribed for the audit committee. And there are some rights of the audit committees as well. Audit committee may call for the comments of the auditors about internal control systems, the scope of the audit, including the observations of the auditor, etc. It shall have the right to review the financial statements before their submission to the board. It may also discuss any related issues with the internal and the statutory auditors and the management of the company. Audit committee may have right to investigate into any matter in relating to the items specified under subsection 4 or referred to it by the board. If board has referred any matter, it can investigate into the matter. So it can have the power to obtain the professional advice from external sources and have full access to information contained in the records of the company. So it is a kind of, by having the majority of independent directors of the audit on the audit committee, so it is a kind of external, okay, you can say the supervision is made on the public limited companies. And then vigil mechanism. We will talk about vigil mechanism now. So it is formed for the directors and employees who may report genuine concerns. Not all companies, but only prescribed companies. Okay, so it is formed, you can say it is formed for directors and employees who may report genuine concerns. Okay, so formation is, it shall be formed by, okay, it shall be formed by it shall be formed by every listed company and prescribed companies as per rules. So this purpose, what is the purpose of this visual mechanism? Okay, it is formed because they can they can report some genuine concerns, okay, through this particular system. So we will not talk much about that. Then we will talk about the nomination and the remuneration committee and the shareholders. Nomination and remuneration committee and shareholders ship committee. Okay, the provisions are given under section 178. So constitution of this committee. So we can say same criteria, similar criteria as audit committee. Okay, similar criteria what we have seen as audit committee. Or you can say instead of constitution you can use the word formation. Formation. Then composition. Here there is a criteria. NRC shall consist of three or more non-executive directors out of which not less than one half shall be IDs. Okay, so this is a composition. So what are the functions? So they talk about, NRC talk about formulation of criteria for qualifications. Will formulate the criteria for the determining qualifications of the independent director. They may recommend the policy regarding the remunerations of the directors. They may recommend for the appointment and removal of for the director's purpose, and for manner for effective evaluation of the performance. And they may define some parameters for the formulation of policies regarding KMPs as well. Okay, so this is the structure of the NRC. In case of the stakeholders relationship committee, so again the formulation is different. Formulation is the board of directors of a company which consists of more than 1000 shareholders, then it is compulsory. SRC shall be headed by chairperson who shall be non-executive directors. Again, objective of SRC shall consider and resolve grievances of the security holders. Okay, so this formation is for the NRC. SRC is a different thing. So here we have completed the audit and its various committees. Then the provisions regarding powers of the board are given under section 179. Powers of the board are given under section 179. So along with the rules, it says that BoD is entitled to exercise same powers as the company is authorized. So board shall be entitled to exercise all such powers. So it says that board shall be entitled to exercise all such powers as the company is authorized to exercise. And to do all such acts and things which the company is authorized to do. Company is authorized to do. Okay. So whenever company will in the Companies Act, the special resolution or the powers are given to the shareholders. Apart from that, board of directors will enjoy all such powers which are required to manage the affairs of the company. The powers of the directors will be exercised from by means of the resolutions. So that we have already done. There are some exclusive powers which are given to the board of directors to make calls on the shareholders in respect of the money unpaid on their dues, to authorize buyback of the securities, to issue securities including debentures, and to borrow monies. So these are some of the exclusive powers which are given to the board of directors through resolutions. Board of directors can delegate some of its powers to the committee of the directors, managing director, manager, or the principal officer of the company. So there can be some restrictions on the powers of board according to section 180 of the Companies Act. So these are some of the provisions which are made in the Companies Act relating to the board and its various committees. I hope you have understood all these provisions very well. So please write down the provisions if you want to make the note of all these provisions, various committees. Audit committee, the criterias. The similar criteria is there for the NRC. Composition of audit committee. Vigil mechanisms. Powers of the board. So here we have completed the meetings of the board and its powers. Thank you so much for watching this video. I hope you understood all these provisions very well. We'll come up with the next topic in the next session. Till then, goodbye.